What's up, everybody? Welcome back. And while we're off court for a couple days for Karen Reed, stuff is not stopping as we have a motion that was renewed by the Commonwealth that seems to be going on right during this trial, where they are trying to block some, if not all, of the expert witnesses that Karen Reed's team wants to call. They may have some legitimate arguments, but maybe they won't. Let's take a look at it, answer your questions, and discuss it together here. So this was a motion that Lally referenced on Thursday that they would be renewing and taking up with the court and arguing first thing Monday morning. Let's take a look at what it is. The Commonwealth's renewed motion for reciprocal discovery and a motion to exclude defendant's expert, Dr. Marie Russell. On April 15, 2024, the day prior to the defendant provided the Commonwealth with a witness list which contains the names of civilians, police, defense, investigators, and experts. On April 22nd, 2024, the Commonwealth filed Commonwealth's renewed motion for reciprocal discovery and renewed request for voir dire of any proposed defense experts during that week of jury impanelment. The defendant was ordered to comply within 1 week with Massachusetts Rule of Criminal Procedure 14. That's the rule on discovery. On April 29th, 2024, opening statements were made and the trial commenced. The defendant sporadically provided reciprocal discovery to the Commonwealth on May 1st, 2024 and May 7th, 2024. See Commonwealth v. Reynolds. A defendant's discovery obligations includes impeachment evidence, allowing the defendant to withhold such evidence against a witness who is certain to be called to testify would undermine the discovery rules and allow attorneys to return to trial by ambush. Theatrics do not accord with our discovery process. I also want to thank everybody for sending this to me, tagging me in it. I think I got this from Sleuthy Goosey is the one that I'm actually using. I'm not positive though, because so many people sent it to me. So I appreciate that. But basically what the Commonwealth is saying at this point is they haven't provided discovery, trials happening. They shouldn't be able to use stuff they're not providing and following the rules of discovery with us. So we're going to ask for some stuff to be excluded or limited in some form or fashion. That's not that outlandish of a request if what they're saying is true, which we're going to find out more in this motion. But I will say, both the defense and the Commonwealth wanted to continue this trial, and the judge said no. So the judge forcing them to go to trial does have a little bit of an angle on this, because if I'm the defense, I'm going to say, Judge, you can't possibly not let us call a witness while we're doing our best to provide discovery during trial where you wouldn't let us continue it, and we told you we needed to continue it to prepare our case, to be ready for trial, to be ready to go, which we were not. And you pushed it anyway. So at least you have to let us continue to provide discovery. The defendant has failed to comply with Massachusetts Rule of Criminal Procedure 14, which requires that the defendant produce all intended expert opinion evidence, including all written reports and opinions that pertain to this case, and the identity of anything upon which the expert bases their opinion. Massachusetts Rule of Criminal Procedure 14A1 provides for an automatic exchange of discovery, regarding intended expert opinion evidence. The Commonwealth again renews its motion for reciprocal discovery. So it sounds like they've talked about this before, but they don't have everything they want or need. On April 15, 2024, the defendant identified Chris Van E., PhD, as a potential expert witness in biomedical and mechanical engineering. The defendant proffered that, and just so you know, with expert discovery, you have to provide the reports and opinions that they're going to make. You don't have to provide reports in most jurisdictions. I'm not positive in Massachusetts, but here you can have an expert that you don't necessarily have to have them make a report. But what you do have to do is at least tell us what they're going to testify to. So you have to know their opinions. Those opinions can either come in the form of a report or in an interrogatory answer where the lawyers can point out or type out, here's what I expect expert X to testify to. That, her blood alcohol content was actually below a 0.08. We expect this person to testify that she never went reverse in the car. We expect this expert to testify that the injuries to John O'Keefe could not have happened from a car. Whatever it's happening, you have to actually give those expert opinions so the other side can prepare, they can cross-examine, they can get experts to rebut or respond to whatever your expert testimony is going to be. It can't be a trial by ambush. We all have to know what everybody's coming with because we want truth and justice to prevail. We want to provide all sides to the jury, not just one side. And if you're just going to fire a bullet that we have no idea what it is, that's not how we want to do it. This is not TV, although it feels like it's made for TV, especially with YouTube and streaming and all this stuff now. That's not really how it's supposed to be. There's not supposed to be a lot of surprises during trial. We are not in the surprise business. We're in the plan and prepare business. Okay, so the defendants proffered that Mr. Van E or I will testify regarding his opinions and conclusions regarding the Commonwealth's reconstruction and the EDR data obtained in connection with this case. That's the CAR data. He will testify to the chronological data derived from the EDR, including key cycles and triggering events from the time period in question. So that's what the defense says he's going to testify to. However, this description fails to comply with Massachusetts Rule of Criminal Procedure 14A4, which requires the defendant disclose the opinion rendered, all intended opinion evidence, and any reports prepared by the expert. So they're basically saying they haven't given us enough. Either we want a report, I'm not sure they have to do a report. Number two, all the intended evidence that he's going to rely on. So maybe they're saying we need what he says the data says, or what he says the reconstruction says, not just that he's going to disagree with or discuss what ours is or put it in chronological order. We need to know what that chronological order is. And this is within the discretion of the judge, how much specificity she is going to require the expert to give. The defendant also identified 3 experts from ARCCA, LLC, Daniel Wolf, PhD, Andrew Rentschler, PhD, Scott Klein, BSME, as expert witnesses in accident reconstruction. The defendant indicated that each expert will, quote unquote, testify consistent with report in possession of the Commonwealth. So it sounds like here, these experts actually did provide a report, and they produced a report that they turned over to the Commonwealth, and that has all our opinions in it. Pursuant to Massachusetts Rule of Criminal Procedure 14A4, the Commonwealth again moves for the defendant to produce all written reports and opinions that pertain to this case and the identity of anything upon which the expert bases his opinion. So again, something we don't see or haven't seen. I don't really want to look at it, right? Because I want to try to stay on the outside as much as I can. But so many of you asked about this. So we're just going to look at what's happening mid-trial. And what's happening is the defense continues to produce evidence and discovery and experts. And the Commonwealth is like, hold on. Trial has started. You can't do this. We're going to talk about where the line is in the balancing act as to whether or not this is actually prejudicial later. Okay, so we don't know if they think there are more opinions than's in their report, that they didn't point to everything they're going to use in their report, or what the issue specifically is with their report, but the Commonwealth again thinks there is not enough. The Commonwealth also moves for the defendant to specify what each of the 3 experts did, what their independent opinion is, and what each expert will testify to. So sometimes with accident reconstructionists, somebody goes out and takes the measurements, somebody takes the picture, somebody puts together the full report, somebody else might actually testify to it because they've got all the letters behind their name. Who knows what they did? I assume they can't call 3 people from the same company to testify to the same exact thing, although it seems like we've gotten some of that in this trial. One person will have to testify to whatever they did, and then there could be an overarching, I'm the supervisor, I tell them what to do, they do it, here are the measurements, here's how it fits in, here's what I came up with for my reconstruction. The Commonwealth also moves to the defendant, I already read that. Furthermore, a voir dire is necessary to determine whether each of these 4 proposed experts are qualified to render an opinion about crash reconstruction, whereas all 4 proposed experts are biomechanical engineers and not crash reconstructionists. So that's interesting. And that doesn't necessarily disqualify them at all, but he's absolutely right. A voir dire, talking about whether or not they are experts, whether or not what they're going to say is going to help the jury in understanding something, that's a question for the judge. That voir dire process is absolutely appropriate. I think Lally should have the opportunity to do that. And I think as I look at this trial, they got plenty of time to do this stuff. There are so many breaks. They could quit an hour early one day or start an hour late one day and handle this. We did a voir dire or a proffer of length. We've done it with multiple witnesses where we send the jury out, the lawyers ask a witness questions, and then the judge makes a decision and we continue on. I don't see why they couldn't fit this into the trial at this point. It's not ideal, and you definitely want to do this before trial. And if they say this was like a tactic by the defense and the judge finds the defense did this to try to trick or act in bad faith or spring something on the Commonwealth, that's inappropriate. I'm not so sure that's what it is, especially since the defense said they needed more time to this trial. The judge said no. So they're trying to push it all and represent their client appropriately. On May 21st, 2024, the defendant provided the Commonwealth with the CV of Dr. Marie Russell, an expert witness not previously disclosed. So this is who they're asking to strike. On May 30th, okay, so May 24th or 21st is obviously after the trial started. May 30th, during the 6th week of trial, Attorney Little for the defense provided the following synopsis about Dr. Russell. So what's she going to testify to? She has reviewed the autopsy photos, the grand jury testimony of Dr. Scorty Bello, the entirety of the autopsy report, all reports associated with Chloe's prior bite history, photographs of the items in evidence, and the UC Davis DNA testing results and evidence submission forms. She is expected to be called with focused testimony, meaning we're going to really hone it in, related to the right arm injuries sustained by Mr. O'Keefe. Dr. Russell will testify that the wounds and injuries on Mr. O'Keefe's right arm are consistent with an animal attack, namely teeth or claw marks, or a combination of both from an animal. She will also testify that these injuries are consistent with having been struck, are inconsistent with having been struck by a vehicle, road rash, or scratches from broken glass from a taillight material. She will base her opinions and conclusions in part on having treated hundreds of patients in the ER with injuries sustained from animal attacks, including dogs. My guess is she also has treated hundreds, if not thousands, of people in the ER as a result of car accidents. So she'll be able to compare the two. That would be my guess. No written reports or opinions from Dr. Russell were provided. So they want more. They want to know, what's she going to actually say? Is she going to say, I mean, it sounds like the injuries are consistent with animals, inconsistent with the car. That's her opinion, but they want it more specifically to say, this will be Dr. Russell's opinion. And the judge may find that they're entitled to that. And I don't think that'd be far outside the box. A criminal defendant's constitutional right to call a witness on her behalf is not absolute and may be limited. In the judge's discretion, in the face of legitimate demands of the adversarial system, the defendant filed the notice of expert 1 day before the trial on April 15th, and for Dr. Russell on May 21st, which was mid-trial, with a synopsis of her opinions over a week later. So they do agree now that that's a synopsis of her opinions during the 6th week of trial. For violations of Massachusetts Rule of Criminal Procedure 14, a judge may, in her discretion, bar these witnesses from testifying. This sanction may not be imposed without a judge's balancing the Commonwealth's interests in enforcing its procedural rules against the defendant's constitutional right to present evidence on her behalf. Okay, before we get to that balancing act, let me tell you one of the issues I have. There's been a lot of talk about Judge Bev being pro-prosecution. I agree. I think I'm less on the spectrum than what a lot of, the bulk of the chat and people watching this case think she's in the bag for them. I've heard some rumblings about a potential conflict. That would be a major issue for me. It would be a major appellate issue if it turns out to be true. I don't know about all those connections, but what I will say is I do think she's prosecution leaning. And if I'm a defense attorney, I don't want to give her any good legitimate reason to make a ruling in favor of the prosecution. And I will tell you, noticing an expert in the 4th or 5th week of trial like they did with Dr. Russell, that gives a pretty easy out to a judge to strike a witness. So if she really was in the bag, in on this cover up, I'm not saying you guys are saying she's in on the cover up. I'm just saying if she really is in the bag for the prosecution, she could have a pretty easy out to strike Dr. Russell. Now, the other witnesses that were noticed earlier and their opinions were given, and some of whom have reports, in my opinion, she may just force the defense to continue to produce discovery to allow the Commonwealth to voir dire those witnesses, ask them questions, make sure they're reliable, make the call on them one at a time if they are actually qualified as experts. And I expect all of them to be able to testify. But Dr. Russell, we're going to look at this balancing act. I'm going to tell you where I stand, but I'm just saying, before I give you where I would be, you don't even want to give a judge you think might be in the bag for the other side any good or legitimate reason to rule against you. And this is not great, right? It's not great timing. Now, I'm not saying they didn't do all they could. Maybe this is a response, and their argument is going to be, this is in response to the DNA expert that said no canine DNA. Now we have no choice but to rebut that and bring our own expert to say that's actually wrong. And this is new information. We didn't know it was going to come out until trial. As soon as we found out about it, we went and got this expert, and boom, now she's here because we have to respond to what the Commonwealth produced. All right, so here's the balancing act. Factors in assessing such a balance include, number one, prevention of a surprise. So when I look at that, the defense talked about Chloe and a dog maybe being involved throughout this case and throughout lots of questions. I believe even in opening statements. So it's no surprise that they're going to make some arguments like this and they might call an expert on it. Number two, evidence of bad faith. Again, We're going to read a little bit later in the motion to see if the Commonwealth has an argument there. From what I see, I don't see bad faith here. 3, prejudice to the Commonwealth. They've already called their DNA expert. They've already had experts like Yuri, which again was why I think is such a mistake, to say, oh, they're very inline, lines that are exactly the same. He didn't say exactly, but, spaced out appropriately. He made it seem like they were uniform lines, not made by scratches or bites. He didn't specifically say that because he can't, because he's not an expert there. But nobody has testified that these are dog bites or scratches or things like that. And I'm not so sure they've had anybody qualified to say that they're not. So how does it really prejudice them? It's bad evidence for them, but that's not what it means when we're balancing prejudicial effect. Because then Karen Reed could say, any witness that says that I said I hit him, they shouldn't be able to testify because it's prejudicial. It's not how it works. Number 4, the effectiveness of less severe sanctions. So as opposed to striking all of the other witnesses, I think we continue to provide discovery, give the Commonwealth what they want, and especially in voir dire, they can even proffer the evidence and say, what are your opinions? They can testify in front of the court. That's a much, much less severe sanction than striking a witness altogether. So all of them, I think, are easily handled with less severe sanctions. But Dr. Russell, how can we handle her? I think it's a her now as I'm reading this, but I think a very similar sanction. Provide discovery. It's not even a sanction. Provide discovery defense ASAP. You only have till the end of the week. Give them a limited amount of time to provide that discovery and the opinions, and allow the Commonwealth to voir dire her as well. Bring her in, ask her questions about her expertise, about her experience, about her education. Ask her what her opinions are, where she gets the basis of her opinion, and if it's either irrelevant, unfair, prejudicial, surprising, or she's not qualified as an expert, the judge will have the opportunity to strike her at that point. But to strike her now doesn't make a lot of sense. The defense hasn't even started their case. The Commonwealth is still in their case. So if they really need to bring another witness, then fine, bring another witness. But they've already brought one to say it's not canine DNA. So they've already kind of started this battle. And if they want to bring somebody in to say this happened from a taillight, I think the defense would welcome that. All right, let's keep reading. The Commonwealth moves to exclude Dr. Russell's testimony as the Commonwealth is prejudiced by extremely late notice of Dr. Russell. Now, that is true. There is an element of prejudice since you didn't even know this witness existed until mid-trial. The Commonwealth has called over 50 witnesses thus far, and a request for continuance 7 weeks into the trial is impractical. Yeah, I agree, a request for continuance, but using one of the off days or the first or last hour of the day, I think is totally appropriate. We do it in every trial. Literally. We do stuff like this in every trial. I hate it. It sucks. I wish we didn't. It's very frustrating for somebody that's OCD and likes a plan and structure, but it's part of the game. The Commonwealth is furthermore, can't call a continuance 7 weeks into trial. It's impractical. In addition, jeopardy is attached, right? They can't have a mistrial because then can't refile. The Commonwealth is furthermore prejudiced by the defendant's decision to elicit this testimony and surprise it has caused. During a final, so this is something I didn't know, obviously, because I didn't watch these hearings. During a final pretrial hearing on February 15, 2024, when asked by the court whether there was any dispute about a canine's involvement or canine DNA, Attorney Yannetti indicated no, and that the defense was not pursuing such claim. It was not until April 29th, 2024, during opening statements. So Yannetti said no. I'm wondering what that exact language was, because he said canine's involvement or canine DNA. So maybe they're not going to say, listen, we know there was no canine DNA, but there's reasons for that. Whatever. I don't know. All right. Opening statements, where contrary to the court's prior ruling that third-party culprit evidence was not admissible or appropriate for opening statements, Attorney Yannetti unfairly prejudiced the Commonwealth by arguing Karen Reed was framed. Her car never struck John O'Keefe. She did not cause his death, and that means somebody else did. And then, surprisingly, proceeded to claim that the defendant's injuries were consistent with a dog attack. Okay, so I guess he did mention an opening. So here's my issue there. If she didn't do it, somebody else must have is a little different than saying it was Mr. Albert who committed this crime. Okay, there's some differences there. But more importantly, and I could be wrong, right, remembering all the way back to opening statements, but did Lally object and ask the court to strike that, which would have been the appropriate remedy at the time? The court could have analyzed and see if this violated her court order, her pretrial order, and she would have instructed him not to go any further there and struck it in front of the jury so it wouldn't even be part of the record. But instead, Lally didn't do that I remember, and instead did this. In light of this, on May 15, 2024, the Commonwealth called Terry Kuhn, a forensic scientist to testify that there was no canine DNA present on the samples provided to her veterinary forensic laboratory. So he decided to, instead of striking it from the record, provide evidence to rebut what was said in opening. And now that door is open. As far as I'm concerned, the jury knows the dog is a question in this case, and they've heard expert testimony from the state saying no dog DNA. Now, he says Ms. Kuhn did not render an opinion about the cause or appearance of John O'Keefe's injuries, nor offered any testimony about whether John O'Keefe's injuries were consistent or inconsistent with an animal attack. I agree, she didn't. Why didn't she? Did you have the opportunity to ask her, Mr. Lally, and you didn't? Was there an objection in a sidebar that we don't know about, or some other argument that prevented you from asking that? Or did you just choose not to? And there is a footnote there that says, due to personal reasons of Ms. Kuhn, an out-of-state witness, she was unavailable after May 16th. Well, is she going to be available anytime through June, even after the defense's case in chief as a rebuttal witness? We might want to figure that out. And I do think the Commonwealth should be provided the opportunity to call her back as a rebuttal witness after the defense provides this testimony. But to say the dog testimony has to be out now after you brought an expert, by the way, what the attorneys say is not evidence. So opening statement is very different than calling an expert witness and putting record evidence in the case before the jury, which the Commonwealth has done now with regards to trying to disprove a dog attack. The Commonwealth is unduly prejudiced by the defendant's intentional delays in providing appropriate discovery and notice to the Commonwealth. So is it intentional? That's going to be a question for the judge. If she finds that it's intentional, there's no doubt in my mind she is not going to allow this testimony or evidence. If she thinks there's bad faith in this situation, there's no way she's going to allow the evidence. I don't see it that way, but I don't know everything that's happened in the pretrial process. So they cited a case that said bad faith when failure to provide discovery is deliberate and willfully motivated by the desire to obtain a tactical advantage that would minimize the effectiveness of cross-examination and the ability to adduce rebuttal evidence. So if that witness is really unavailable and the Commonwealth can't come up with another witness, it's going to be a really important question as to whether or not they could have just asked this witness this on the stand. I don't remember the defense are objecting, saying we can't talk about canine stuff. So if you had the opportunity to ask the questions and you didn't, at some point it might just be on you. We'll see. Again, we don't hear sidebars, so we don't know. But were they really willfully delaying? Were they trying to get a tactical advantage or have a trial by ambush? Nobody wants that, especially the judge. All right, furthermore, the proposed testimony of Dr. Russell may necessitate a Daubert-Lanigan hearing where the defendant bears the burden of establishing that the proposed testimony would assist the trier of fact and that the methodology underlying the expert testimony is sufficiently reliable. Okay, so this is just basically a Daubert challenge. This is something to say that this expert's not qualified to be an expert or their testimony is not expert testimony. It's like me saying, I have 10 fingers. Everybody knows that. It's not really assisting the jury. But if I talk about how fingernails grow because I'm an expert in that, then fine, that can assist the jury. So is her saying, it doesn't look like a dog bite or dog scratch, or it does look like a dog bite or dog scratch, is that just to the naked eye? Or does she have expertise and reason to be able to assist the jury in a higher level than just the jury's own eyes and ears and understanding? That's going to be the question before the judge. The trial judge must also determine whether the witness has sufficient knowledge of the facts and expertise to render an opinion. Of note, Dr. Russell's expertise is with treating patients in emergency room and how injuries may appear on living individuals rather than how injuries are depicted on a deceased male and in a postmortem photograph and after sitting in the freezing cold snow for 6 hours-ish. So that could be a differentiation, that her expertise is people coming into the hospital, not later. But it's also she sees them heal. She knows what they look like and what they would look like healed. If it's a scratch, how far apart they are, what they usually look like. I mean, I think if you're going to call an expert for something like this, an ER doc or an ER vet doc, I think would be the two best types of witnesses to call. All right. And again, I would mix in there what it looks like after car accidents because ER doctors see tons of car accidents. As for the experts disclosed on April 15th, the Commonwealth again moves in order that the defendant Commonwealth moves in order that the defendant produce the appropriate proffers, opinion evidence, and expert reports forthwith so that the Commonwealth can adequately prepare for cross-examination. I agree. That needs to happen ASAP. no delay. I frankly would have ordered it over the weekend and said, you better have this stuff by Monday, because they should have that. They should have what they relied on and what their opinions are now. We're 6 weeks into this trial. As to Dr. Russell, the Commonwealth moves for an order to exclude her testimony entirely, as there is no less severe sanction to ameliorize the surprise, bad faith, and outrageously delayed disclosure. The Commonwealth bears the burden of proof and production at trial and cannot try the case while simultaneously working to understand and rebut testimony from experts whose reports and opinions it does not have, without which the Commonwealth is prejudiced and unable to effectively prepare for cross-examination of these witnesses. So while this does suck, it happens all the time. I wish it didn't. It's happened to me. I don't think I've ever produced something mid-trial, so I can't say I do it to other lawyers, but it absolutely has happened to me in criminal cases and civil cases. And in order to have a fair trial, in civil cases, the judge is like, well, do you want to just mistry it and do it again because I find this relevant and important? It's going to be an appellate issue. Criminal cases, much harder to just kind of agree on a mistrial. But what I will say is, I think the same order that's going to happen for the other 3 witnesses should also happen to Dr. Russell. Provide everything over the weekend ASAP and allow the Commonwealth to voir dire the witness during a day next week where they have a break. That's what I would do if I was the judge, because why wouldn't you want all of the information, all of the evidence, all the truth to come out and let the jury make a decision? And if there's 2 experts that say 2 different things, let the jury weigh their credibility and make a decision. There was a second footnote here. Should the defendant again fail to produce the appropriate opinion evidence, the Commonwealth may move to exclude all the experts, those experts as well. So if they don't produce more discovery, enough that the judge thinks it's okay and appropriate, then they think all of those witnesses should be out as well. So we'll see. We'll hear the arguments on Monday. I'm recording this on Friday, so I don't know if the defense is going to file their response. If they do, I'm sure you guys will tag me in it. Maybe I'll tack it on to the end of this video, or we'll just talk about it later. But you guys asked me about it. It's pretty interesting. It's interesting to know that the defense does have reconstruction experts coming. How could a car possibly have made this happen? What do those injuries indicate? Do they indicate dog or car or neither or a fight? What are we going to see? What are we going to learn? It seems like the defense's case is going to be heavy on the expert side. But we'll wait and watch it together. Make sure you guys hit that like button if you haven't already. Subscribe to our page. We'll continue following this trial with you. Till next time, I'm out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, The Lawyer You Know.